Thank you, Madam Chair. I'm going to first address the question about the participation of NGOs in the preparation of the state's periodic report. Speaking for my group, which is one of the major gender equality groups in Singapore, AWARE, as well as my colleagues at home who run the most established domestic workers shelter, as well as colleagues in Sayoni, the LBT Women's Group, and Project X, the sex workers group. While there was a presentation of the state report to us subsequent to its compilation, I do not think that we have had any substantive input into the content of the state's periodic report. With regards to the question about Article 12 of the Constitution and the 2014 case of the Singapore Court of Appeal, I believe the question is whether the unfortunate outcome in that case results from the fact that it was a challenge to a law criminalizing sex between men. Had the challenge been brought by a woman in regards to gender inequality, would Article 12.1 have been adequate grounds for bringing a non-discrimination challenge? Although we do not have a test case that can verify this, my reading of the Court of Appeal's judgment is that the answer is no. Besides the phrase cited, which that it's the Article 12.1 is declaratory and aspirational in nature, the court actually goes into some detail in discussing the difference between the, quote, reasonable classification test, which it sees 12.1 as embodying, and a substantive test of discrimination, which it sees as being more applicable in the case of Article 12.2 of the Constitution. It uses language such as that 12.1 refers to a, quote, minimal threshold function of requiring logic and coherence, unquote, in the law. I believe that this is a statement about formal equality before the law and not substantive equality regardless of sex and gender, which is what CEDAW requires. But I have to acknowledge that there has not been a case which has tested this. The next question that I would turn to is about the application of the Protection from Harassment Act in reality. This is a piece of legislation that we welcome. We are glad that there is a legal standard now declaring what harassment is and that it is unacceptable. However, there are certain difficulties with its practical application. First of all, none of the criminal offences that it establishes are seizable, and therefore police action in respect of these cases may not necessarily be forthcoming. Second, the civil law process that's established by the Act, in our experience, is too complex. Most of the clients of, none, maybe almost none, very, very few of the clients of our sexual assault care centre are interested in seeking a protection order under this legislation because it is too difficult, complex, and expensive. And lastly, and very critically, there is no requirement on employers to include any kind of anti-harassment measures in their workplace. And so people who are faced with workplace harassment don't necessarily want to start criminal prosecutions or start applying for protection orders against their colleagues. They just want their bosses to stop what's going on and let them get on with working. And that's not something that employers are currently required to do. Next question regarding the levels of women's representation in various fields. I'm afraid we don't have those statistics to hand, but we will do our best to provide them to you subsequently. Regarding the fact that we now have a female president, I cannot answer the question what took us so long, but I would like to note that while it is obviously a very historic move that we now have a woman president, the criteria set out in the Constitution for people who can be candidates for the presidency are extremely limiting. And moreover, in particular, they limit possible candidates to the former holders of senior offices in which women are highly underrepresented. So we should not see the underlying architecture of the presidential criteria as one that would encourage more women candidates in the future. Next, on the question of measures at a legislative level, we acknowledge that there have been passage of anti-harassment and anti-trafficking legislation, but we are extremely disappointed at the continuing persistence of marital immunity for rape, as well as the lack of action on improving the legislative position of domestic workers. Next, before I pass to my colleagues, I do not have statistics on foreign wives who are deported for being HIV positive. I would suggest that the situation is more akin to death by 1,000 cuts, where you're not necessarily deported, but you just get extremely limited residence passes. Perhaps you have to keep going in and out of the country every few weeks or every few months in order to renew them, and you are excluded from many services. And so it's not necessarily a case of straightforward deportation, but it obviously has a great impact on their livelihood. On the question of domestic workers, I'll pass the floor to my colleague Jolivan from Home.
Yes, please.
Can you hear? Okay. Good afternoon, everyone. I shall now address the issues concerning migrant domestic workers. A question was asked about what the immediate direct priority for migrant domestic workers are, and I must acknowledge that this is a question that is very difficult to answer because migrant domestic workers face severe and systemic discrimination and marginalization in Singapore. Many of them they have limited access to economic, social, and cultural rights. Their living conditions are poor. Many of them don't have enough food. And it is difficult for them to seek access to justice. But in our conversations and in our casework, we have assisted thousands of migrant domestic workers in the past 13 years. And one of the key concerns that affect them is that they do not have the right to switch employers freely. So any rights that they are entitled to is difficult for them to claim simply because they are afraid of angering their employers and having their employment terminated and being repatriated to their home countries. The right to switch employers freely is fundamental because in Singapore, domestic workers can only work for the employer that has applied for the work permit for them. It is difficult for them to switch to another employer. It is very similar to the kafala system in the Middle East. And many domestic workers who come to us have been reluctant to file complaints, or to assert their rights because they are afraid of losing their jobs. So the fundamental right to switch employers freely is something which we would say is the immediate direct priority for migrant domestic workers. With regard to mandatory HIV testing and health testing for women migrant workers, and this applies to all women migrant workers, not just domestic workers, it is true that if they are found to be HIV positive, and that they will be deported. The same applies to women migrant workers who are found to be pregnant. Their work permits will be revoked and they will be deported. Many of them are also blacklisted and prevented from coming back to Singapore to work because of their HIV status and because they have been pregnant. Thank you.
Allow me to add on the response to the domestic workers in Singapore. I think there are other few key priorities that we hope that the government also really have to consider. I think the change of employer system should actually be urgently extended to all the distressed workers. This is to assure them that while they have suffered victims of any of the abuse or problem with the employers, they will be able to continue to work in Singapore. But more importantly, I think we need to push for the transparencies of the placement fees that's been charged by both the agent from the sending country and the receiving country. The next priority that we think that should be for the consideration of the government is to actually put in place a system to ensure that all employers will pay their salary through the electronic mode and to enable all workers to have a bank account. That will actually help to reduce the salary disputes for every one of them. And more importantly, it's a skills certification system to ensure that all workers' skills are recognized.
Thank you very much. The last speaker, please.
Thank you, Madam Chair. I'm going to respond regarding the question on older women and the Pioneer Generation package specifically, and also the Silver Support Scheme question. The question is, are these the Pioneer Generation Package, which is actually provided by the government to provide healthcare benefits for all pioneers, those who are 65 in 2014. We don't know if there's an impact yet because we haven't had any study evaluation from the government data, and we hope that there will be that's gender disaggregated and age disaggregated as well. So we look forward to that. Regarding the Silver Support Scheme, is it gender responsive? We know that since women are more proportionately represented in the older age groups, there are actually more women benefiting from these measures. However, because the criteria is based on housing, it disadvantages women who are living in larger units because they live with their families, and but as individuals, they have lower incomes or they may not have no income at all. So there's the benefits that they can get out of this Silver Support Scheme is not disadvantaged because they're living with their children who may be in a larger homes. And so therefore also, since this is a new scheme also, there's no evaluation yet, and we look forward to the gender and age disaggregated data. Thank you very much.
Thank you very much. And now